welcome to OCLRE's Moot Court Brief Writing Webinar Series. My name is Danny Rains, and I'm the Moot Court Coordinator at OCLRE. For this first introductory episode of our webinar series, we are joined by Ben Tracy, who is going to walk us through his entire brief writing process and tell us a little bit about all the different stages that you're going to learn about in future webinars. Ben works as an appellate attorney with the Franklin County Prosecutor's Office. Ben, can you tell us a little bit more about your experience with appellate advocacy?
Sure thing, Danny, and thank you for having me. Hello, everyone. As Danny mentioned, I'm Ben Tracy, and I have a lot of appellate experience. I was in private practice for a number of years at a small firm where I handled all appellate matters for that firm. Then I was at the 10th District Court of Appeals as a staff attorney. I was senior judicial attorney on the Ohio Supreme Court for approximately 4 years, and now I'm an appellate prosecutor with the Franklin County Prosecutor's Office, where I do appellate advocacy all day, every day. As a matter of fact, I had an oral argument this morning.
Why should teachers and students care about your brief writing process?
Well, that's a fair question. And to be honest with you, I'm going to give an unconventional answer. I'm not sure that they should, except to say that everyone needs to have a process, because a brief is a complicated document. And if you don't have a process, if you don't have an idea of where you're going, it can seem like an impossible task. It can seem too big to conquer. But if you have steps, if you know what you're going to do first, if you know what you're going to do next, and you have faith in your own process, and you have faith that everything's going to come together in the end, then you know that the mountain that looks unassailable will eventually be summited. And you know that you will reach that summit and look back on your work and be proud of what you've done.
Everyone seems to agree that brief writing is an incredibly difficult process. What about it makes it so challenging?
Well, gosh, where to start? So, when you're writing a brief, you are trying to be concise. You are trying to summarize everything that has happened during an entire trial process. You are trying to do it in a way that is persuasive and understandable to people who weren't there in the trial and who don't know what the case is about. And then on top of that, you also have to tell them about the law. So you have to explain an incredibly complicated factual and procedural scenario, and then you also have to explain an incredibly complicated set of law. You have to do it in a confined and organized way, and you have to do it in a way that's understandable to someone who doesn't already know about it. And just for added fun, you have to be persuasive. And you also have to not seem to be persuasive. You have to seem credible and honest. Nobody likes a salesman, but people love a good story.
You've mentioned in our previous conversations that your brief writing process could be broken down into like categories of steps. Can you give us a little bit of an overview before we look at the specific steps of the process?
Gosh, yes. So I would say the initial category is familiarizing yourself with the case, because when you're doing appeals, whether it's for a competition or in real life, you are generally not the same person who did the trial. So you have to get an idea of what you're dealing with from a big, high-up picture where you can kind of see everything. Once you've got that, then you have to go deep, and you have to understand everything that happened. Once you know what that looks like, then you have to go and you have to look and see what the contentions are of the other side. And you have to think about those. Then you have to research the law. Now, fortunately, in a competition, we give you the law. So you don't have to do your own research. And believe me, doing your own research can be quite a battle. So you are up a leg on this already. You have reason for confidence. But once you understand the law, then you have to think about how does the law apply to your case. You have to think about how to organize it. You have to think about headings. And then once you've got it all in this package, and it's all neatly written, then you have to check it, right? Because when you are doing a brief or you're trying to persuade someone of something, you cannot be wrong in even the smallest detail. Because if you're wrong about one little thing, or one little thing seems sloppy, or one little thing seems out of place, well, then the person may start to doubt all the other things that you've told them, things which they otherwise wouldn't doubt. So that's the broad categories.
When you're starting working on a brief for a new case, what is the first thing you do? Is there a sort of mindset or thought process that you always come back to at the beginning?
Yeah, so the very first thing I do is I try and identify what are the big issues in the case. And the good news is that's normally pretty easy. Whether it's in a competition or in real life practice, your opponent, or in the case of a competition, your packet, will tell you straight out, what are the big questions here? What are the big issues? Now, if you're the one doing the appeal, sometimes you have to read some of the background and try and figure out what the big issues are, but normally that's something that's going to be ascertainable pretty quickly. So my first step is trying to figure out what are the big questions in the case.
What do you do to make sure that you've mastered the record and you understand everything that's going on in the case?
Well, number one is read everything. Can't stress that enough. There's no way to know stuff without reading it. And it sounds really obvious, but you'd be amazed how many people feel like kind of skimming through and sort of identifying this or that to look at later is important and is enough. No, you have to read everything. And because of the way my brain works and because of the way I think most people's brains work, I recommend approaching that process chronologically. Start with the first thing that happened. Start with the complaint. Start with the indictment. Start with, in your case file, the facts. What happened first? What happened next? Get a really good grasp of that.
All right. How do you analyze the issues of the case to make sure that you're framing it right from the very beginning?
Sure. So when you're trying to think about the issues in the case, first thing you have to figure out is what's the other side saying? Because if you don't know what your opposition looks like, if you don't know what the other side's saying, then how can you even begin to formulate a response? So try and think about what they might have to say about the facts. Once you have a handle on that, the next thing is figure out, what do I want to say about the facts? And it's important when you're thinking about what the other side is going to say, when you're thinking about how to combat what they're going to say, it's important to give them their due. You may have heard about making a straw man as a way of approaching argument, where you present a weak version of your opponent's argument and then you tear it to pieces. This is a bad argument technique. I would encourage you to try for the steel man. Make the strongest, most powerful version of what you think the other side is going to argue, and then start looking for holes in the armor. Start looking for things that you absolutely need to say to drive your sword through the other side's armor.
Are there any specific strategies, this might be what you just covered, to make sure that you are capturing all the angles of the case?
I mean, it's a little bit of what I just said, in the sense that what you really want to do is you want to try and put yourself in the other side's shoes. I think to be a really good prosecutor, you also have to be a good defense attorney. And I think to be a good defense attorney, you'd have to be a good prosecutor. You have to be able to think on both sides of the question, which is one of the reasons I've made a point in my professional career to try and be on all sides. I've been a defense attorney, I'm now a prosecutor, and I've worked for courts. Because you need to have objectivity. You need to see how the other side sees things. You need to see how your side sees things. And you need to be able to imagine how things are going to appear to a judge or the court or the panel or whomever you are presenting to.
Now, in the real world, you have to actually do legal research. And our competition, the people in the competition, they get the case law handed to them. do you have any advice for how they should approach that case law as if it were the fruits of their own legal research?
Yeah. So when you are thinking about citing a case, there are a few things that you need to keep in mind. One, read the whole case, right? You might get half a page in and discover a quote that works super well for what you want to say. But in reading the whole case, you might discover that that quote is perhaps not in the context you thought it was. There are sometimes when a court will say something and then spend the next 20 pages pointing out why the thing it initially brought up was wrong. And then it'll finish by reaching the opposite conclusion. So you always want to make sure you understand the full facts of everything that happened in the case. You want to read the whole thing before you think about whether you should use any part of it. Once you decide to use a part of it, you need to decide which part and for what proposition. And I think it's most effective to use cases sort of like this. Have the first part of the sentence be your words, and then when you get to an appropriate point, drop a comma, drop quotation marks, and finish it with a quote from the case. The reason I recommend using shorter quotes is because I think long block quotes can sometimes lose reader attention. I'm not saying never use them, but be sparing. And having no quote at all, I think, leads the reader to doubt, gee, does this case really say what this person says it does? But if you can use the court's own words, well, that's sort of an unassailable source, isn't it?
How do you write your statement of facts and explain the case in a way that is both concise but also allows for any nuance that's necessary in the case?
Right. Statement of facts. This is one of the most difficult things to do well. So when you're doing a statement of facts, you want to present the facts in a way that shows your client's position in a good light. You want to be persuasive, but you don't want anyone reading those facts to realize that you're being persuasive. And you also can't leave things out. This is difficult. The way I like to approach it is by being thorough. I think to myself, on my side of the case, what are the things that are going to help me win? And I'm going to put those front and center. I'm going to reference them as often as I can without being repetitive. But I'm also going to think to myself, if I were a judge reading this, what are the things that I would really want to know if I were making a decision? What are the things that if I made the decision and I found out later about something that was left out, what are the things that I would be mad if I found out later? And those are the things that even though they're not good for you, you'd better put in your facts section, because if you don't put it in, the other side will, and when the other side does, you're going to look dishonest because you didn't. So you have to include the bad facts along with the good ones. But because you're including the bad facts, you can do it in a way, hopefully, that will allow you to be gentler with how they're introduced. And you can also take the opportunity to explain some of the bad facts. The final thing I'll say about writing a facts section is don't do commentary. Facts section is not the time for commentary. Present the facts in a way that leans your side, but don't comment on them.
Right. How do you decide what order to present the facts or the propositions that you're including in your brief?
So a recitation of facts should be chronological. Having said that, there are different ways to approach a chronology. So one way to approach it would be procedural chronology. That is, you could start with this person was convicted on this date, or they were indicted on this date. The evidence at trial was this. This witness testified to this witness testified to that, and so on. Another way you could do it, which is harder but sometimes more effective because human beings like a good story, is to start at the beginning of the event. And for a competition where your procedure is less complicated and you are given the facts, I generally think it's most effective to tell the story of what happened. Just be factual about how you state things. Avoid adverbs. Tell people what happened. Accentuate the details that are helpful to you. Don't hide the bad details, but don't accentuate them either. That's how you persuade without being persuasive.
You said we have to understand the other side when you're build the steel man. How do we perceive or prepare for the objections or skepticism of our argument if we're putting ourselves in that position? How do we find those weaknesses in our own argument?
You know, it's not really an intellectual exercise. It's an emotional one. Think to yourself what your argument is. And then dig deep and think, what question, if you were in front of a panel, what question would make you feel afraid? What question would make you feel like, oh my gosh, deer in the headlights? Whatever that question is, that's the question you need to answer. And you need to answer it well.
Do you ever have to adjust your strategy for the facts or any other part of the brief while you're writing?
All the time. Never, never, never become so in love with something that you've written that you can't change it. Always be realistic. You know, you might have an idea for a theme, and this goes for oral argument as well. You might have an idea for a theme, and it might really seem like a zinger to you, and you might just love it. And then when you get in, you might start feeling a little bit of gnawing. And you might think to yourself, gosh, I don't know, that doesn't fit so well. Well, I'll just avoid that detail, make sure it fits my theme. Well, I'll just avoid that detail. Don't do that. Details matter. Pick your theme based on your facts and your details, and don't be afraid to change if it isn't working. You can't change the facts, you can't change the law. What you can change is your theme and how you're approaching them.
What's the key to, we talked about the facts of the case and sort of how to, and the application of the law. How do we write the argument section, the section that we get to be persuasive in? Sure.
So with facts, I mentioned that you want to be persuasive, but sometimes you can't, right? I mean, sometimes there just isn't a great way to do that. Sometimes you have facts that just aren't very helpful to you. The important thing is at the end of the facts section, you've told the truth, you've established credibility, you haven't hidden anything, and so by this point in time, your reader is ready to trust you. Now it's time to use that trust. You've told them a story about the facts of the case. Now tell them a story about the law. Humans love stories. No one pays attention if you just tell them, okay, the law is this and that and the other thing, bullet point, bullet point, bullet point. No. No one cares about that stuff. What you have to do instead is you have to tell a story about what the law is and why it makes sense. And sometimes that story might also be how the law came to be that way. Not always, but sometimes. But the one thing you always want to answer is why. Why? Why is the law this way? Why does it make sense? And so what you're going to do is you're going to lay out what the law is. You're going to lay out how it applies to the facts that you just brought out, and you're going to explain why that makes sense, why it makes sense for your client, why it makes sense for lots of people. Because remember, appellate advocacy isn't just about that case. Anything that you want a court to do has to make sense in that case and every other case that comes afterwards.
So the ending, the conclusion of our brief, how do we write that so that it will have a lasting impact and persuade the court to do the thing we want them to do?
So by the time you've reached the conclusion, hopefully your reader knows that you're trustworthy. They know that you're a trustworthy historian of fact, which is easily verifiable, so that's one that you really don't want to mess up. Hopefully, they know that you're a trustworthy historian of the law. And hopefully, as you did your argument section, you told them a story about the law, you told them how it fit in with your facts, you told them why it makes sense based on your facts, and hopefully you didn't do the thing which I sometimes call going a bridge too far, which is asking someone to accept a proposition or accept an argument that you don't really need to win. When you're talking about your argument section, you want to always be focused on exactly and only what you need to win. And if you've done all those things properly, they're ready to believe you. And so now it's time with the conclusion to tie it up in a neat bow. So all those points along the way that were so vital to helping you win, pick the 3 or 4 most vital, the things which when stated just make it abundantly clear that you win. Lay those out in the conclusion, 1 sentence apiece, and then at the end, ask for what you want. Always tell the court what you want. If you want reversal, ask for that. If you want reversal and remand, ask for that. If you want affirmance, ask for that. Tell the court what you want. And don't be afraid to be a little creative, too, in the conclusion. In the facts section, you shouldn't generally be creative. You should be stating things in a measured way. But the conclusion, if you're going to have a little flair, if you're going to leave someone with a little snappy one-liner, the conclusion is the place to do it.
So headings can be really important in the long briefs that we have to write. What role do they play in the overall structure of the brief?
Headings are always important, always. Headings are the things that allow a reader to feel like they're not lost at sea, right? When you look at a big brief, if it didn't have headings, it would just be a wall of text. Imagine reading a novel with no chapters and no paragraphs, right? It would be a chore. And no matter how good your brief is, it's probably not going to be as interesting as a really well-written novel. So you need to give someone something to hang on to. Something where when they start to go like this as they're reading your brief, they can go, okay, where am I? Right, this heading. This tells me where I am. This tells me what this chunk of text is about. And so when I'm reading it, I have context before I've even started. I like to do this with nested headings. So for example, I'll have a heading that says introduction. I'll have a heading that says facts. I'll have a heading that says argument or discussion. And I'll have a heading that says conclusion. But as I'm going through my argument, I might have, let's say, 3 or 4 really important arguments. Each one of those will get a heading. So if argument is Roman numeral, introduction 1, facts 2, argument Roman numeral 3, then my first nested heading might be A. A, whether or not the court should have done X. B, whether or not the court should have done Y. I mean, whatever it is, have your headings be descriptive. Once you're past the main section headings, have descriptive headings. Make sure that they're short, not more than a line or 2 at most, and that they give your reader something to hang on to.
I've heard introductions can be a little controversial whether or not you include them. What makes writing an introduction so challenging, and what's your approach to writing the introduction?
Sure. So introductions are vitally important, and you should always have an introduction. Whether it's called an introduction, that can depend on the court. Some courts, for example, want to see a statement of issues presented. You should use that as an introduction. What you are trying to accomplish with the introduction is you are trying to present your best argument, your very best points. You're trying to present them in a way that makes them seem utterly obvious. You're trying to present them in a way that makes them seem simple. And you're trying to present them in a way that is brief. And finally, they also have to be understandable to someone who knows nothing about the case. Because remember, the person hasn't read the rest yet. It's the introduction, right? So how do you do that? Well, I'm not going to lie, it's really hard. I probably spend more revision cycles making the introduction understandable, believable, easy than anything else. But the one tip I will tell you, and I think it's absolutely essential, don't even think about writing an introduction until the entire rest of the brief is done. Because you don't know when you start out what your best points are going to be. Oh, you think you know, but by the end, you'll have a different view on it. Trust me on that one. The introduction should mirror your conclusion. But the introduction is harder than the conclusion because by the conclusion, the person's read everything else, so they have context. The introduction has to provide its own context, and it has to still do it simply. It's a difficult task. Save it for last.
What's your approach to writing the issues presented or assignment of error? Is that different from the other sections of the brief that you've talked about so far?
If you're in a court that doesn't give you the option of using an introduction, I sometimes use assignments of error or issues presented as an introduction in the sense that I might say something like, the other side says this, but we think that the core issues in the case are these. Whether you're using it as an introduction or not, when you're doing issues presented or assignments of error or whatever they're called, what you're trying to do is you are trying to set out in numerical or a bulleted way what are the questions that must be answered in the case. These can be legal questions, they can be factual questions, they can be a combination of the two. But when you're stating them, you want to state the question or the issue in a way that makes it seem obvious and that draws a conclusion that is only favorable to your side. It's not easy. Honestly, the easiest part of the brief is the facts section. Because the facts section, you're just telling people exactly what happened, and you're doing it in a persuasive way without seeming persuasive. By the time you're on issues presented, which, like the introduction, is the very last thing you should do, you are trying to take everything you've done and smush it down into a sentence or two. It's not easy. Don't be afraid to take some time and work at it.
What is your process for reviewing it before revising and polishing your brief?
Well, for an initial review, once you've got it all written, I think it helps to read it through silently, make some corrections, maybe then run a spell check, grammar check, right? Those are important. Then I like to read it aloud. Maybe print it off even. Get out your red pen. When you read things aloud, you will discover that your brain is a sneaky thing. And that when you're reading silently, you can read words that aren't there. You can read words as other words. You can read things that you thought you wrote, but which you didn't write. When you slow down and you read aloud, particularly if you actually read to someone else or you imagine you're reading to someone else, you will find suddenly that you are reading exactly what's on the page. And you'll also find, gosh, some of these sentences are really awkward. When you encounter that, fix it. Fix it. Do it right then. Get out your red pen. Don't be afraid to break up sentences, too. Lawyers sometimes, we create very long sentences because there's lots of little caveats, lots of little exactitudes that we feel we have to put in there. That's okay. Don't dilute your meaning, but don't be afraid to have shorter sentences. Also, when you read aloud, you're going to discover something that is well known to novelists and poets, which is that cadence matters. Sometimes you want to have a short sentence. Sometimes you want to have a long sentence. Sometimes words sound good together. Sometimes they don't. It is a mistake to imagine that just because you're writing for a legal audience, those things don't matter. Judges are, among other things, human. So make sure what you're writing is enjoyable for a human to read.
How do you deal with the fatigue of working on the same document for so long?
You know, I think that's why it's really important to have steps. You know, because you can set for yourself a goal. You can say, okay, today I'm going to do the fact section. If you said to yourself, okay, today I am going to read and understand everything in this file, I'm going to read and understand everything about the law, and I'm going to write the entire brief, A, you won't manage it, and B, you will get very discouraged, because if that is your goal, thinking I'm just going to finish this thing, it's going to seem impossible. It's going to seem unassailable. And so what you want to do is you want to keep in mind these steps, and you want to decide each day, what's the thing that I'm going to do today?
How do you go about checking your citations to make sure that they support your position?
Yeah, I mean, there's no way to do it except to just be really rigorous with yourself. Any factual assertion should be followed by a citation. Any legal assertion should be followed by a citation. Assuming you've been doing that while you're writing the brief, at the end of your process, you're going to go back through. And every sentence that you read, when you get to the citation, you are going to take the information in your citation, you're going to get out your packet, or you're going to, in a real case, you'd get on perhaps a legal research service, or you'd get on the trial court docket, or you'd get into your file, and you're going to go follow your own citation. You're going to pretend that you're the judge and that you're interested in figuring out where this fact came from, and you're going to follow your own citation, and you're going to see if you can find that fact. And if you can't find that fact by following your citation, then you're going to do one of two things. One, hopefully, you're going to figure out that your fact is still true and that you just did the wrong citation. And so you're going to go figure out what is the right citation, and you're going to fix the citation. Option two, which also sometimes happens, is you're going to figure out that you thought something said something, but it really didn't. And at that point, remember, because we have to be absolutely 100% honest all the time, because we have to have the trust of our reader if we want to win, at that point, you probably need to think about stating the fact in a different way, or perhaps just deleting that portion. When you have quotes, when you're checking those, I highly recommend selecting and cutting and pasting from the document you are quoting into a blank notepad or a blank Word document, and then taking your own citation and copy and pasting it underneath and doing a comparison, because that's a good way to determine if your quote is accurate. Nothing destroys your credibility faster and more permanently than saying a quotation that isn't real.
When you are done with that step, you mentioned previously that you have a colleague read your stuff, or you would recommend peer review.
Absolutely.
How do you decide who to have read who do you give your brief to, and what do you hope to get from them?
Sure. On the question of how we review and who we get to review stuff, well, it depends what you want. So sometimes, if you're concerned that your brief isn't intelligible, it's not a bad idea to have someone read it who doesn't know anything about the case. On the other hand, if your concern is that a particular point of law may be tenuous or difficult, well, then your best option is to have someone read it who knows a lot about the case in that area of law. So who you have review your brief, I think, varies depending on what your concern is. But to be perfectly honest with you, I'd do both.
How do you know when your brief is ready to submit? It's done and dusted.
Yeah. So that's the other nice thing about having a process. You don't have to wonder. Once you've addressed all the arguments that you need to address to win, it's important to stop writing. But as we've already talked about, the end of writing isn't the end of the process. The end of writing is just the beginning of editing. So how do you know when you've edited enough and polished enough? Well, that's why it's important to have a process. So for me, the process is this. Read it through, make any changes. Read it through aloud, make any changes. Do your spell check, check your citations, have someone else read it. If at any point someone who's reading it for you brings up a very serious concern that requires a rewrite, your editing process starts again. But once you've done that, once you've had someone else read it and they've pronounced it good, that's the moment to say, okay, yes, I'm done. You can keep rereading your own stuff, and you will find things every time that you might think to yourself, gosh, I could just do this a little bit differently. Don't do that to yourself. Done is done. When the process is over, you're done. Because otherwise, you can spend all the time in the world on something.
What would you say is the most common mistake that new writers might make in their brief?
Gosh. Most common. That's really hard. Unfortunately, there's a lot of mistakes that can be made in the brief writing process. I will say the most grievous mistake is dishonesty. If you shade the facts, if you don't tell the truth about the law, if you make those sorts of errors in judgment, you are blowing your credibility forever. I mean, you're not just going to lose that case. You're probably going to lose most of your cases because people won't trust what you have to say. So never, ever, ever make that mistake. I won't say that's the most common one, though. I think the most common one is probably just sloppiness. It's people who don't spend the time, who don't have a process, who just kind of wing it, or perhaps use AI, which AI is incredibly useful, but AI doesn't think. It only pretends to think. It's a pattern recognition piece of software. It doesn't have judgment. And a good lawyer's prime requisite is good judgment.
Do you have, if you could offer one piece of advice to someone who this is the first time they're going to be writing a brief, what would you give them?
Don't be overwhelmed. Trust that you are going to be able to do this. If you take it in small steps, if you set for yourself a goal each day, one thing to do, understand the issues, read the record, read the law, draft the fact section, draft the first big point of your argument section, the second big point, the third, the conclusion, the introduction, the issues presented. If you go step by step, You will get there.
Any other advice or thoughts that you think that our viewers should know?
Brief writing may seem like a chore when you first encounter it. But I'm going to tell you, it's my absolute favorite thing to do. When I go into the office and I know I don't have to do anything except write a good brief, it's a great day. It's a wonderful opportunity to use your creativity, to maximally use your intelligence, to sculpt reality for a person based on your words. It's an incredible thing. So try to enjoy it. You may not initially, because it is a learning curve, but once you get it, once you understand how magical it is to create reality with words, it's a little bit like being a wizard. And who wouldn't like to be a wizard?
Thank you. Thank you for taking time out of your day to sit with us and talk about brief writing.
Danny, it's my pleasure.